funny because it was the same moment when in Geneva at the same time Egypt's report was being considered at the Human Rights Committee. And I got there.
The Judge of the Supreme Court of India, who will chair the morning session. And we are also very pleased to welcome Justice Defy Rebello, Chief Justice of the Allahabad High Court, and many of our judges of the Allahabad High Court. I think there are about 6 or 7 honorable justices who have come here today. They would have been here yesterday, except that the Allahabad High Court had a working day on Saturday, so we missed many of you judges yesterday. For those of you who were not here yesterday, we have Lord Walker of the UK Supreme Court. He spoke yesterday and he will speak today again. We have to his left Justice Palm of the European Court of Human Rights, who spoke yesterday of the decisions of the European Court. To the right of Justice Ganguly, we have Justice Kate O'Regan of the Constitutional Court of South Africa. And to my left is Anthony Lester, Lord Anthony Lester, Queen's Counsel and the architect of the Human Rights Act in the UK. We'll start.
Day in India. And if I may say so, it's a coincidence of history that the UK Human Rights Act of 1998 was implemented on 2nd October, which is again the birthday of Mahatma Gandhi. So today we are all meeting silence. For the High Court, I think request him to make his presentation.
Good morning, Mr. Chairperson, fellow participants. Yesterday, we had a very interesting discussion on equality and non-discrimination and views from different parts of the globe. I'm very grateful to Mr. Gonzalez and his team for having invited me here. And I think before I come to my presentation, which I make it sure that I don't exceed my allotted 15 minutes. But I would like to preface with a few remarks. I think we need such sort of colloquia more often because in India, most of us judges do not interact too much with the academia. We are not too much in contact with the academic world, and this gives an opportunity to get a jurisprudential point of view on certain issues. And one of these issues yesterday was equality and non-discrimination. One thing which I noticed yesterday and which was pointed out also by Lord Walker as well as by Lord Walker also was that in Europe and the advanced countries, most of the cases arise out of individual rights, whereas here we are facing more, we need this equality more because of class action. It's more because of the class inequalities which are more here. And in a country like India where inequalities are even more, there needs to be, just the Chief Justice Mukhopadhyay called it discrimination. I mean, it's affirmative discrimination, but I would still not use the word because that still brings in an element of discrimination. I would say what the Supreme Court said in Indira Sahni's case, affirmative action. You require affirmative action to make unequals equal at times. So where there is this gross inequality in the system, then we definitely need. So the concept of equality also will vary from the advanced countries and developing countries. Because discrimination here has been brought in with the purpose of making unequals equal. Because as we're going back to Aristotle, equals can only be treated equals with equals and not with unequals. And yesterday was a pleasure hearing Professor Kenneth and Professor Castellano, especially a lively presentation by him and also by Judge HRLN from the Supreme Court. The concept of equality, in my view, is a fairly amorphous concept. I mean, how do you can't really define it. I've been thinking over it after hearing all of you yesterday, but can you put in, you can't put it in any, define it in any particular terms. It will have to come on the facts and circumstances of each case, from the societal, the pressures of society. Like in India, caste is a big issue, which would not be there in Europe, but as pointed out yesterday, in England, in the UK Human Rights Act, there is a provision to bring in caste also as a caste discrimination also in the near future, and maybe things. So, therefore, the need also to interact more often. But again, I would like to, at the risk of repetition, say that this concept cannot be put in any straight-jacket terms. So it will have to develop over a period of time. Coming to my presentation, I have I am presenting the role of the Himachal High Court since the time was limited only in respect of persons with disabilities. So there were a lot of other decisions, and I only want to point out one other decision before I come to my main presentation is that yesterday when Judge Reagan was reading out the Constitution of the Supreme Court, I found it interesting that the burden is on the state to show that there is discrimination is required. And in Himachal High Court, in one of the cases decided about 2 years back, we had also issued a direction, though it was not on the burden of proof as such, but we had, following the Supreme Court judgment in Nagaraj's case, the High Court of Himachal Pradesh had decided that the state could make reservations in promotional avenues under the amended provisions of Section 16(4) of the Constitution only if it first gathered information and material to show that these classes of people were not represented sufficiently in those posts. And that decision has been upheld by the Supreme Court. My main presentation is basically on this persons with disabilities. Yesterday only Justice Sikri from the Delhi High Court had touched on this aspect. This is a very neglected part of our society. In India, we tend to hide the disabled. I found that especially people who are mentally challenged, families are not willing to acknowledge their very existence in certain strata of society. Therefore, the need here to give privileges to the disabled or to give them some means of either earning their livelihood, in fact, first of all, going in for proper education, earning their livelihood, and affirmative action was required. Like most other Asian countries, India was way behind, and it was only in 1993 that in Beijing a conference was held, and pursuant to that, in 1996 we enacted the Act, the Persons with Disabilities Equal Opportunities Protection of Rights and Full Participation Act 1995. I mean, the objects of the Act I need not go through in detail, but basically it provided that the state has a responsibility to protect their rights, to ensure that they are not discriminated against, ensure that they are given proper medical care, education, training, employment and rehabilitation of persons with disabilities. Like in all other acts, even prior to the amendment to this act being brought into force, in Indira Sahni's case, the Supreme Court had recognized the fact that the disabled formed a class for which reservation could have been made even without such such an act. But despite the decision in Indira Sahni's case, despite the act being brought onto the statute book, nothing was being done. And therefore, the court had to step in. And what Lord Lester had yesterday said, that Indian judges rush in where angels fear to tread, into the law-making arena. Sometimes we are required to do so, unless we prod the government, sometimes really shake it from the head, no action is taken. And this is what happened exactly in this case. 96, this act comes into force, which, as I developed, it gave a lot of rights to the disabled, but no action was taken. There was a association of visually handicapped persons, they filed one petition, but they limited it to a very limited point of giving them reservation in employment, 3% reservation as provided under the Act. Then one of the younger lawyers there filed a pro bono litigation, bringing in the other aspects of the Act, and the court decided to hear this matter covering all aspects. There were about 5 petitions which were heard together. And we found that the Act was being breached by the state more than it was being followed. There was actually total breach of the Act. Provisions were being violated. The first and foremost was that the Act defined who were disabled, and under that the state had to set up an agency to identify the disabled. Because unless you identify the disabled, how do you give them the advantages which they are entitled to under the Act? And nothing had been done in 11 years, so the court gave directions that that the coordination committees would be set up within a particular time limit, and within 6 months they would identify everybody in the state, and then every year they would continue to monitor and take necessary action. Therefore, all children below the age of 12 years were directed by the court to be checked up by the state government to see that they are not covered by this, they are not suffering any disability which would bring them within the purview of the Act. And then we directed that from 31st October of every year they would do this. Then the Act itself contained a provision that the state had to take action in bringing these provisions to the notice of the people. But what to talk about bringing it to the notice of the people, the officials in the government themselves did not know about the Act. Therefore it was brought to them. And I am talking about a state which in India, Himachal Pradesh where I come from, for the last 4 or 5 years, on social indices has been marked as the best state in the country. We have the highest literacy rate today of about 85%. Despite this Act was not being implemented. Therefore, the need and what the Indian Supreme Court is a continuing mandamus, monitoring how the Act was being implemented. The first and foremost which we found was that the Act provided that children under the age of 18 years had to be given free education. Under the amended Constitution, new amendment, there is a fundamental right up to the age of 14 years. Now the Act provides 18 years. When we brought it to the notice of the government, and this is where the government responded very well, and they said, what to talk about 18 years? Till university we will provide not only free education, but also free transportation, material, books, etc. So that was the first result which we had. The government itself filed an affidavit that we will do this. Then we found that it had not even appointed a commissioner to look into the complaints of the disabled. 11 years had elapsed by that time. So the commissioners were appointed so that there was a fora to approach the courts, for the disabled to approach redressal of their grievances. We also, the court, at the instance of the court, the state made a provision that all disabled children having 40% disability or more would get free education right from enrollment to schools till passing out from the universities, including technical and professional courses in the state. So the state not only complied with Section 26, but gave better benefits than what were. But there was another angle to it. The Act says that you must ensure that they study in the same schools as the ordinary children study. And the purpose behind it that they intermingle and they don't feel segregated from the other children. Here the state took a view that no, especially the children who are visually impaired or handicapped, they cannot hear, or they need special schools. This led to a situation where we couldn't expect the state to set up schools for these special schools for these people in different parts of, they could only set it up a few schools. And that would mean that the children would be separated from the parents. So then we gave directions that we will ensure that in a taluka or something, there would be at least one or two teachers who would be trained to deal with these sort of students, and the children could go so that they are not separated from the parents at a young age, and they would go to schools near their homes, and they did not have to go to specialized schools, and they would go to the common schools and study along with all other children. Rest were some issues of providing individual benefits, which I will not go into. The other important aspect was that Section 28 of the Act provides that the appropriate government shall initiate or cause to initiate research by official and non-government agencies for the purpose of designing and developing new assistive devices, teaching aids, special teaching materials, etc. Now this again, nobody had done. So the court gave directions, mandamus was issued, that they set up a committee in this behalf. And it has, since we're monitoring it, it has led to great improvement. I won't say that this system has become perfect, but definitely there's great improvement in this system. And Section 29 provided that they have to set up training teacher institute to develop trained manpower for schools to teach children with disabilities. Again, here the state was in breach. No action had been taken even on this. The state took the plea. It's a small, Himachal, though the area is quite large, the population is only 60 lakhs, small in Indian standards. So the state took the plea that we don't have the funds to provide so many schools. Then the court, and they said we would go to other states to give teachers, to get the teachers trained. The court had, you can't do that. This mandate of the Act is that each state has to. We said we can understand that you set up one or two such institutions, but finally two institutions have been set up to teach. These are to teach the ordinary teachers how to deal with students having disabilities. Then we came to what Justice Sikri had also referred to yesterday, about the identification of posts for persons suffering from disability. Now this was a typical catch-32 situation where the government would not identify the posts which the disabled which could be reserved for the disabled. So virtually nullifying the provision of reservation of 3%. So then we gave a direction that if within a period of 1 year you do not identify the post, then it will be deemed that the disabled can man the post. So we just turned it opposite, that unless you identify a post that a disabled person cannot man it, then it will be deemed that he can man such a post, and therefore there would be reservation. There was some opposition on the administrative side of the High Court also to this, because for posts of judges, but fortunately because of the Supreme Court intervened in the Supreme Court decision in the IAS officer's case, we have reserved in the administrative side also. Though we have made certain provisions what sort of disabled people can take up these posts or not. The other interesting aspect was that we developed in another case, we developed this law. This is Om Prakash Gupta's case, where we said that when you come for promotion, now there is no reservation in promotion. In fact, in one judgment, the Himachal High Court said that this reservation is only at the level of in getting a job, not at the level of getting a promotion. But we said at the same time, though there may not be reservation, you cannot discriminate on the ground of disability. So if a person is disabled, you cannot deny him the promotion which otherwise he, according to the seniority rule, would be entitled to. And that decision, I am not going into detail because that's sub judice before the Supreme Court. When 3% posts, according to the Act, were to be reserved, now the state first tried to nullify this by not identifying the post which we dealt with in this manner. And we directed them to give, relying on a Kerala High Court judgment in the All Kerala Parents Association for the Hearing Impaired. And here we took advantage of Collins' book on the disabled. That was the only compilation in the country which had cases relating to the disabled. And I'm sorry, but it's not been updated. It's still the 2005 edition. Yesterday I saw it. So you need to really, because there's a lot of law which has developed after 2005. Justice Sanjay Kishan's judgment in the Delhi High Court, this judgment from Himachal, which has not been reported anywhere. And so the court held, we are of the firm view that the state cannot be permitted to circumvent the mandate of section 32 of the Act by fixing roster points at 30. In India, we have this system where roster points are fixed for reserved categories, because when 15 forces provide reservations, then we fix roster points. Now what the state did was they fixed the roster points for the disabled at 33, 66 and 99. Effectively, again, saying that nobody, so then the court, I mean, this is not strictly speaking within the domain of the court, but we said to make it effective, it should be somewhere in the first 6, 7 roster points, and consequently the further changes would take. Then some aspects I'm not covering because the Justice Sikri covered them yesterday, and I don't want to repeat. So, but we held the need of the disabled is for today, and it cannot wait for the future. Because the state kept saying 11 has already left. The Act makes no distinction between various categories of posts, including the posts falling in the administrative service. And therefore, we directed that the state is bound to make similar reservation in the administrative service and judicial service in the state. Lastly, I'll just come to one issue. Again, after the directions were issued,
I think, Judge, you're almost...
just 2 minutes.
Okay.
After we did this also, in the university they came up with a novel method again of circumventing the Act. They said that they will make the reservation category-wise, professors of the university, etc. Now section 30 and 32 provided that it has to be across the establishment. Then we said it has to be across the entire teaching board. That's a new decision in Munish Datta's case, just given in October. So these aspects we again held that it was discrimination against the disabled if you don't give them their rights in accordance with the Act. Thank you.
Thank you very much. And who is our next speaker? This is Baba.
So you can start with your session, so we will not come.
Not come?
Both will not come, sir. Just start with us.
So sorry. Well, I don't know, are the learned judges all right? I mean, Winter has taken a toll of them? Okay, we wish that they join us for lunch a little later. But I'll just say one word. I'm trying to difficult to sum up what you have said, but anyway, in one word it comes from one sentence. Again, I'm referring to Gandhiji. He said, look at the importance of what he said. He said the rich must live simply, so that the poor can simply live. You see, the rich people in India, they don't follow him. They refuse to just simply live. Anyway, thank you for your presentation, and you have tried to give an overview of various judgments which have been delivered by different high courts.
We left only with the Himachal High Court, or that was the brief.
No, but you have referred to Kerala.
Yes, Kerala and a few others.
So therefore, well, I'm sure because the learned judges have come from abroad, they know the judicial structure in our country. In our country, each state has a high court, which is the apex court so far as the state is concerned. And the Supreme Court is merely an appeal court, an appellate forum. By no means the High Court is inferior to the Supreme Court. Both are constitutional courts and both have equal rights, excepting possibly Supreme Court has one or two under the Constitution in order to meet the ends of justice. It's a very wide range of powers of the Honorable Supreme Court, otherwise the courts are the same. We in Supreme Court, we depend very much on the High Court, because it's to them that these constitutional judges go first, and on their decision depends the entire constitutional structure of the apex court. The Right of Children to Free and Compulsory Education Act 2009. I'll come to the Act a little later. But if you compare it with Article 24, which is also in the chapter on fundamental right, it says no child below the age of 14 years shall be to engage a child. But if it is not in a factory or mine, or is not in a hazardous employment, he can be employed. What happens to his right under Article 21A? Whenever you move on the streets of India, you will find there are various tea shops on the roadsides. There are plenty of them. And most of them, if you go there, ask for a cup of tea, the person will come and serve you tea is a child. So the employer says that I am not violating the Constitution. I can engage him. It's not a factory or a mine. Serving tea is not hazardous. So I am within the permissible guarantee under the Constitution. Then what happens in those very minor areas, mine, factories or hazardous employment? I would say, even though I have taken an oath to uphold and abide by the Constitution, which I do, the time has come to reconsider Article 24. Because Article 21A, which casts an obligation on the state, and acting under the same obligation, the state has made a law, which is this law. Now if I come to this law, I'll just bring to your attention the statement of objects and reasons. It says, the proposed legislation is anchored in the belief that the values of equality on which you have spoken, social justice and democracy, players inappropriate policy and poor educational infrastructure in villages, resource crunch, lack of awareness. Now we are told, this is also said in Commission's decision, that education up to the age of 14 is a fundamental right. And beyond that, it's also a fundamental right, but it cannot be made part of an enforceable right because it depends on the economic capacity of the government. Now you see every day in India, the economic capacity of the government is eroded by monumental, mammoth proportion of corruption in every field. I mean, it is very difficult to list the number of scams which are now going on. Very difficult to count on your fingers. And in some of them, the courts are trying to sort of find out some kind of remedy to track those who are involved. Very difficult. Court is finding great obstacles in its way. So all these, if you look at what Engels said, that an educated society cannot be kept repressed for long. And what Hitler said, don't spread education. So look at this dichotomy, said about 100 years ago. It is still not following. They are saying that we can't educate people because we don't have funds. The government is funds constrained. And at the same time, the way the government fund is being vested. This cancer of corruption can only be tackled by education. Nothing else. You now look at the very dismal situation in this country. In 1991, this child labor was 1.13 crore. Now today 2001 is 1.26 crore. And in this Uttar Pradesh, the Chief Justice should know, the learned Chief Justice is leading the pack. 19,21,977 people. They are engaged in various kinds of labor. And what are they not? They are in street work, they are in sex industry, they are in Zardoshi industry, it's a kind of garment industry, glass factories, it's very hazardous, but they are there. Match factories, carpet industry, brass impact, because the Juvenile Justice Act, it's this action in Child Labour Prohibition and Regulation Act. But the basic focus is missing to carry on their duty as a judge. I call it duty as a judge, not only their power, it's not a question of power, it's their duty as a judge. To exercise the duty in such a way that constitutional promise becomes a reality. It is very important that today we should take the pledge. As I have started by saying, the rich people in India should live simply, and the poor can simply live. Thank you for your attention.